Lawyers representing Deputy Chief Justice Philomena Mwilu have given their oral arguments to have Queen's Counsel Khawar Qureshi prohibited from prosecuting the Director of Public Prosecution's case against their client. The lawyers argue that before the five-judge bench appointed by Chief Justice David Maraga, the court also heard arguments on the DPP's application to have Senators James Orengo and Okongo Omogeni prohibited from representing Mwilu in the suit. And we have our reporter Olive Barrows, who's been following the case in Milimani for the latest. But of course, let's just listen in to what is currently happening.
She is not prejudiced. She has not instructed them. It does not affect her case at all. The petitioner has instituted this suit in her private capacity. It is not an office that has moved to court. It is not a body corporate. It is an individual alleging infringement of her specific individual rights. It's not a group suit. Somebody else can't come and bring a grievance that has no nexus with the case. If they have a problem with the AG's exercising its power and DPP, let them file their own case. My submissions in response to the submissions by my colleague Mr. Kimoli in support of Mr. Harvey's application are that those are hypothetical scenarios. It's full of conjecture, suppositions, presumptions. Courts don't deal with hypothetical scenarios. Courts deal with historical facts. Real controversies, not imagined scenarios. I will be polite that don't consider those submissions. They have no basis in law whatsoever. We have relied on 3 decisions by several judges of the High Court. And all of them are in concurrence that when it comes to advocate deponing to contentious matter, that is improper. You elect whether you want to be an advocate or a witness. Our first case is the one by Stephen K. Oyugi versus the Law Society of Kenya and Sanjeev Kagram. It's in our bundle represented before the court. And I would wish to rivet the court's attention to page the authority is not paginated. It's on page 5, the 5th page of that decision. And you will find an often quoted case of Kissi Investments Limited and another versus Kenya Finance Corporation Limited, where those principles were clearly enunciated by, as it then was, the Honorable Justice Aaron Ringera. And they are set out in page 5 of that decision of Stephen K. Oyugi. Because of time, I don't wish to just go through them. But in the subsequent paragraph from where they've been highlighted, you will notice that the Honorable Justice Ojwang in this case agreed with him. And he said that the plaintiff's objection, in my view, is well-founded. And that you'll find also in the subsequent cases that we have highlighted, the Ajib Kenya Limited versus Highlands Tire Limited, in terms of the principle that an advocate cannot depone to contentious matters. And further, to just buttress that, the petitioner has not alleged any disability that will have prevented her from deponing to those to supporting affidavits. There's nothing that bars her. And finally, because I'm